Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.
Judge, I'll start with Haley. The indictment is not required to allege that the defendant knew that false statements would come to the attention of a covered entity. That's an evidentiary concern, not a pleading requirement. How do we know that? Because in Haley, if I flip the slide, Haley told us exactly what the indictment in that case alleged. It did not allege that. And if the indictment in Haley had to allege that in order to allege a crime, then the court in Haley would have dismissed the case because the indictment itself never alleged a crime in the first place, and a general demurrer issue can be raised at any time. So it clearly does not impose an additional pleading requirement. You have to separately plead knowing and willful as it relates to knowledge that will come to the attention of someone. That is purely an evidentiary requirement. The trial does not impose any additional pleading requirements. It's irrelevant that the legislature is not a department or agency of state government. Haley tells us that as well. Simply, the false statement must concern a matter within the jurisdiction of a municipal, county, or state department or agency. To whom that statement is made is not relevant. In Haley, it wasn't made directly to any person. It was put on YouTube, and it was put out for public consumption. And coincidentally, in this case, the legislative hearings were broadcast on YouTube as well. The contention that the false statements cannot be prosecuted because the same statements were made in immunized legal pleadings, that's unsupported. There's no authority that legal pleadings are immune from prosecution. This was raised in the briefs. To the contrary, there are specific statutes that criminalize false statements in pleadings, and we cited in our brief a couple of instances, such as an attorney being disciplined for making frivolous pleadings and filings. OCGA 51-911 creates a civil cause of action for defamation of title involving false pleadings, and then 161020.1 obviously makes it a felony offense to file false documents. So I'm not sure where this idea of immunized legal pleadings comes from, but it's not supported. Legislative privilege does not apply to statements made by third parties to legislators. Defendants, again, provide no authority for that contention. It's raised in the briefs. You look at the Constitution, the constitutional provision, Article 3, Section 4, Paragraph 9, that creates legislative privilege. It's very clear that it applies to members of either house, not to the general public who shows up and serves as a witness. The fact that they're not under oath, again, is not relevant. That would create a different crime. We're talking about false statements, and we've alleged the essential elements of false statements. Again, under the defendant's theory, in Haley, if that defendant had come to the legislature as a witness and said that he was the catch-me killer and killed 16 people, knowing that that was going to be broadcast live to the world, for whatever reason he would be immune because he said it at the legislature, that doesn't make any sense. There's no requirement that the counts concerning false documents allege that they were used anywhere in particular. That's not an element of the offense. In any case, we've talked about how for special demurrer purposes, you can look at other counts of the indictment, and other counts of the indictment allege where those specifically named documents were used, how they were used. And this is the citation I was looking for in the last argument. Although each count of an indictment must be complete within itself, contain every allegation essential to constitute the crime, that applies to the offense, not the form, and the indictment is read as a whole. Special demurrer, of course, is a challenge to the form of the indictment, so that rule of count having to be complete does not apply in the context of a special demurrer, only a general demurrer. We got an argument in the pleadings that the Secretary of State and the GBI don't have jurisdiction over these false statements. That's looking at facts outside the indictment that constitutes a speaking demurrer. There's no requirement, this is raised in the briefs, that the counts alleged defendants knew that their false statements would cause harm, not an element of the offense. No authority that false statements cannot apply to statements made to the federal government, raised in the briefs. Again, the recipient of the false statement is not an element of the offense. So it doesn't matter. As long as we allege that it's in a matter within the jurisdiction of one of these agencies, and then we prove at trial that there there was knowledge that it would come to their attention. In any case, the indictment alleges that those false documents were also transmitted to state officials. And again, we got the rule of lenity argument. We saw this come up a lot in the pleadings. I think this is the first time that it's come up.
I think you handled that. I haven't seen it come up yet today in argument. I think you've addressed it in the briefs.
I think it briefly was mentioned in argument.
We hear it? Okay.
And so just to highlight here, I understand that there's kind of there's a lot of federal case law that was cited in the briefs on this issue, but the Georgia version of rule of lenity, where we see it applied over and over again, is that it's a rule of sentencing. So if you get convicted of 2 offenses, one provides a lesser sentence, but they're the same act or same elements, you're entitled to the lesser sentence. The Court of Appeals this year noted that the defendant in Huber, 368 Georgia Act 401, has provided no authority, and we have found none, for the proposition that the rule of lenity can subject to demur an otherwise sufficient indictment. So our position is that while there may be in the federal cases that are cited a different application of the rule of lenity, under Georgia cases, it's not a reason to dismiss the case. Motion should be denied as to these counts. It's irrelevant where or to whom the false statements were made. There's no support for this idea of immune legal pleadings. Legislative privilege only applies to legislators, and in a few situations, their staffers. And other arguments seek to add elements that are not set forth by statute, or they're simply voice speaking.
All right. Thank you, Mr. Wooten.
Very briefly, Judge, if you're going to have to prove something at trial, it's an element of the offense. If you don't have to prove it at trial, it's not an element of the offense. Obviously, Haley said it is an element of the offense that you knowingly and willfully do that. They don't plead that. They have no response to that. They admit they don't plead it. The claim has to go. With regard to legislative privilege, we're not arguing legislative privilege. What we are arguing is that when somebody comes and speaks in front of the legislature, we have a separation of powers problem, because if they're speaking in front of the legislator, invited to do that, and somebody comes in and hits them for what they say in front of the legislature, that is an issue. And with regard to the rule of lenity, that's exactly what Haley was doing. Is the rule of lenity is a rule of statutory construction, and when you're looking at these statutes, you have to interpret them in a manner that would make them constitutional. If it's ambiguous, you read them against the state. And here it says you've got to have these 2 elements. One thing that I would want to point out to Your Honor is we've seen this obviously in the Haley case and in others. In the federal context, there was a case, Rahif, that talks about criminalizing the possession of firearms by a legal alien. And the Supreme Court, much as in Haley, came back and said, listen, you have to have both elements have to be knowing. I have to know that I possess a firearm, and I have to know that I'm illegally in this country. And those both became elements of the crimes. The United States U.S. Attorney's Office have changed their pleading requirements for that, and have done exactly what the state should have done here, which is modify the way that they plead these cases. And what they should have pled here is that said statements are knowingly and willfully within the jurisdiction. That's not there. The claim fails.
All right. Who do we have for impersonating an officer?
Richard Bryson. To begin with, counts 8 and 9 charge. Count 8 charges the substantive count of impersonating an officer, i.e. the electors who reportedly unlawfully, falsely held themselves out as the duly elected and qualified presidential electors. Count 9 is a conspiracy to commit impersonating a public officer, and specifically references count 8. Now, nowhere in the statute, 161023, does it define what a public officer is. The only definition I found applicable in the Georgia Constitution, Article 1, Section 2, Paragraph 1, it defines a public officer as a trustee or servant of the people, and thus is amenable to the people at all times. And as the Georgia Supreme Court said in Kennedy v. Carlton, the intent and purpose of this particular section of 1610-23 was to protect the people of the state from intimidation and other potential abuses and dangers in the hands of someone who is cloaking themselves in the authority of the state of Georgia or an officer. And thus, there must be some nexus between the public office and the alleged criminal acts. In other words, not every criminal act committed by a public officer constitutes a violation of 1610. Now, Georgia law recognizes that presidential electors perform the duties required of them by the Constitution and laws of the United States. In other words, they're not necessarily performing the duties and laws, the responsibilities required by the Georgia Constitution. They are acting pursuant to the U.S. Constitution. That's contained in OCGA 21-211. And indeed, as cited in our brief, U.S. Representative Caldwell remarked that, quote, the elector is a federal functionary as much as a senator or representative, and the duties of an elector, as soon as he is chosen by the state, are prescribed by the Constitution of the United States. These electors were chosen well before the election. I think it was in March or April of 2020. When they stepped up to fulfill their duties, whatever they did as their regular job, whether it was a state senator or any other public officer, when they were functioning as an elector, they were performing a federal function and exercising duties and responsibilities under the U.S. Constitution and the Electoral College. This is not a state or local government function.
And this was an argument that was addressed, or was it touched on by Judge Jones in the removal action, right? And so what do you contend was the error in that decision?
Well, the difference is, I believe, in the removal action, they said there was more to the entire case than simply what was going on as federal function. In these particular counts, we are focused in only on what they were doing as an elector and whether or not that qualified as a public officer under this criminal statute. So even you can have a situation where Judge Jones holding that it wasn't subject to removal, but that does not mean they qualify as a public officer under this criminal statute. Now, cut to the chase. The federal elector, their status as not being a Georgia public officer is analogous to a state grand juror. A state grand juror performs duties in connection with the Superior Court. They're paid for his or her time. They're serving for a designated period of time. But nonetheless, they are not a public official under this section. We cited a case of Duffy versus Ferguson, 178 Georgia 230. And so what we have here is the alleged representations all pertain to a federal function made by someone who is acting in a federal capacity, and they are not Georgia officers. Now, the state cites Garrison State with the grand conclusion that this utterly defeats our argument. Now, the Garrison case, what it addressed was the sufficiency of the evidence. And in that case, Garrison and his co-defendants, they went to steal dope from a house, kicked in the door, wearing masks, brandishing guns, they yelled at federal agents. In the Garrison case, there is not a citation to 1610-23. Not a discussion of it, not a citation to it. The Garrison case does say he impersonated an officer, but when you dig a little deeper and you look at the indictment in the Garrison case, where's your honor?
Are you tendering this as part of the record?
Yes.
An exhibit?
If you look at the indictment,
What exhibit are we tendering this as?
today would be Exhibit 1.
All right.
If you mark the...
All right. Any objection for the purposes of this hearing?
Judge, again, like our prior objection, just to relevance.
All right. Okay, it'll be admitted for the purpose of the record, for this hearing only.
So when you look at the actual indictment, the indictment that came out of Carroll County, count 8 is the impersonating an officer. Oddly enough, even that count does not cite a statute. But when you look at it, it simply says that impersonating an officer, more specifically, he falsely held himself out to be a peace officer with intent to mislead. Now, when you look at the disposition, which is further back of that exhibit, frankly, it doesn't clear up what statute he was actually charged with. But I will note he received a 1-year sentence, which would be consistent with a misdemeanor. And there is a misdemeanor code section that covers this, OCGA 40, Tac 6, Tac 395, which criminalizes impersonating a sheriff, a deputy sheriff, a state trooper, agent of the GBI, or an agent of the Federal Bureau of Investigation, police officer, or any other authorized law enforcement. While the opinion in Garrison v. State does not clear up that confusion one way or another, and frankly, nor does the indictment, I would suggest to the extent that the court gave any credence or precedential value to the state citation, when you look at what was actually done in that case, the most likely statute of conviction was not 161023. It was 46395. Which all tracks back to the fact that we do not have a Georgia public officer. And under the ECA, as argued by Ms. Pearson and Mr. Gillen previously today, the alternate slate of electors was convened. They acted to preserve the election challenge while the judicial challenge was pending. And so, even if they were public officers, the statute, which they were not, under the ECA, there still would not have been a conspiracy to commit an unlawful act. Because as the court noted in its ruling on the speedy trial defense, although you came to a completely different conclusion, in State v. Cohen, the general demur is appropriate when it's a conspiracy to commit a crime that in fact is not unlawful. And in this case, holding themselves out as the duly appointed and elected Republican Party electors is not in and of itself a crime. They were the Republican electors. They held themselves out as the Republican electors. And as such, they do not constitute, or even admitting every fact and allegation in counts 8 and 9, they still would be not guilty of those counts and subject to general
Defendants aren't charged with holding themselves out as Republican electors. They're charged with holding themselves out as the duly elected and qualified electors from the state of Georgia, which is a very different thing. Just to point that out first. Again, each count alleges all the essential elements of the offense, apprises the defendant of what they must be prepared to meet. The trial provides enough detail to protect against public jeopardy. Georgia case law does not, as we pointed out in our briefs, and as the other side tried to rebut, Georgia case law does not limit 161023 to state officers. We know that from Libri versus the state, 346 Georgia at 420. In that case, there was a conviction upheld where they just impersonated a fictitious agency. It wasn't even an actual public officer. It was a Metro Atlanta Human Trafficking Task Force that did not exist, and the Court of Appeals said that's fine. Again, Garrison, which was just talked about, but the case very clearly upholds the conviction where the defendant in that case said that he is a federal agent. I mean, I'm looking at this indictment, And I believe this helps our position because if you look at count 8 of the indictment, the language exactly tracks 1610-23, and it says, it accuses them of holding themselves or stating that they were federal agents, contrary to the laws of said state. So I'm not quite sure how Garrison hurts us, nor am I sure how the indictment in Garrison hurts us, because it shows this is an indictment that alleges something very similar to our indictment, and it was upheld. And notwithstanding that, presidential electors are clearly state officers. They're not federal officers. We talked about In re Green earlier this morning. In re Green, very old case, makes it very clear that they are state officers. They are not federal officers. And there are multiple statutes, Georgia statutes, that refer to the office of presidential elector. So there is some argument that they're like grand jurors. They're not like grand jurors. It's an office. They run for office. They qualify to be on the ballot. They get paid a little bit, I think. But there's at least 4 different statutes in the code that specifically refer to the office of presidential elector. So it's very clear that the code contemplates that they are public officers. These motions should be denied. Again, the essential elements are pled, sufficient detail to survive special demurrer. The statute is not limited to state officers. In any case, they are state officers. Thank you.
Your Honor, just a couple of things. First, Mr. Wooten is incorrect. The electors are not elected representatives of the state of Georgia. The slate of electors are not necessarily senators. In fact, I think most of them are not elected officials. They're private citizens, usually those who are contributing or active in a particular political party. So the mere fact that they are an elector does not mean they are a Georgia public officer. And he's again incorrect in that the slate of electors for both parties had been selected months prior to the election. So the fact that they stood up and said, we are the Republican electors, President Trump, if he won and if the judicial contest was successful, does not convert them into a Georgia public officer as defined in that criminal statute. And again, the point in the intent of the General Assembly in passing this statute was to protect our citizens that are cloaking themselves in the authority of a Georgia public officer. And look at almost all of the cases involve police officers who take some action that's illegal in the context of their law enforcement duties, whether it's, one of the cases cited, attacking a female that they had pulled over for a traffic offense. Things such as that. They are within the cloak, within the authority of their Georgia public office. State electors do not fall in that same category. They are simply designated by a particular party to stand up and cast those electoral votes if their candidate wins. They are not necessarily Georgia senators or Georgia legislatures. In fact, most of them were not. In this case, again, frankly,
All right, moving along. Forgery. And the counts 10, 11, 16, 19.
Under counts 11 and 17, and then similarly counts 10 and 16, are a conspiracy to commit forgery in the first degree in violation of Code Section 16.9, Tab 1B. The unlawful conspiracy involved making the certificate of votes of the 2020 electors, making the electoral votes, and casting those. As Ms. Pearson persuasively established earlier, the ECA does authorize and permits the alternate contingent stated electors to undertake those actions that are criminally charged in counts 11 and 17. And based on that argument alone, these counts are subject to error. Additionally, in the state's response, what the state has said is that they are only proceeding on kind of the final prong of that particular statute. And in that statute, what it criminalizes in that fifth prong is that a person commits the offense of forgery in the first degree, one with the intent to defraud. He or she makes, alters, or possesses a writing or check, or, I'm quoting, or by authority of one who did not give such authority and utters or delivers such writing. A high school English teacher would blanch by written a statement or a sentence like that. It makes no sense. But what we have in this case is we have the contingent alternate slave electors who held themselves out to be themselves. They were selected and identified prior to the election, and they were in fact the Republican slave electors. They didn't hold themselves out to anything other than being that. But more importantly, for purposes of the demurrer, the statute specifically says that the forgery is creation of a writing by authority of one who did not give such authority. And one of the things we've said is that the indictment fails to identify who the person was who did not give the authority. And with that omission, the indictment is subject to demurrer. Notably, the statute does not say made by one who did not have such authority. And perhaps if the statute said that, we'd be in a different position with regard to this count. But that is not what is criminalized. What is criminalized is making that writing by authority of one who did not give such authority. And so we are left to guess, and it isn't contained in the indictment, preceding factual averments, who failed to give us that authority. It is a gap in that charge, it is a gap in the indictment, and it subjects it to general demurrer. The state seemingly concedes that the indictment doesn't contain the required specificity when they say. Moreover, when the alleged deficiencies in one count, it can be read by looking at all the other counts. Now, I would suggest that Mr. Wooten has selectively utilized that. We talked about count 23. He said, well, it's not, it doesn't say that in that account, but it did talk about sending in the electoral votes in this in previous counts and in previous factual averments. But in this particular instance, it does not clear it up. This does not say anywhere in any of the 161 counts that were asked, in any of the 41 counts charges, it does not say who did not give them that authority. And that is something that is specifically required by the statute. And their failure to include that in the charging document requires the defense basically to guess at that and subjects this charge, both of these charges, to a general demurrer. I'm sorry, to a special demurrer.
Judge, I'll try to be brief. First of all, the indictment does specify whose authority the documents were purported to have been made under. It's the presidential electors of the state of Georgia. Right there in the indictment. They allege all the essential elements. They advise the defendant of what they must be prepared to meet, provide enough detail to protect against public jeopardy. I think this was argued in the briefs that we had to, allege forgery in one particular way, and alleging that it was made, the document was made by authority of one who did not give such authority was not sufficient. That was argued in the briefs, but I think that's kind of shifted in the argument, and the defendants are acknowledging that that is a way to allege a violation of 1691, and that's the way of violating the statute that we rely on in this indictment, and that's legally sufficient. And so I'll kind of skip through examples of the other ways that it can be violated. The indictment is not required to allege that the writing was intended to defraud anyone in particular. Intent to defraud a particular person is not an element of the offense. In any case, again, read as a whole, that's appropriate for special demurrer purposes. It's very clear that these specific documents were intended to defraud the President of the United States Senate, Archivist, Georgia Secretary of State, and the Chief District Court Judge. These motions should be denied. We plead all the essential elements, sufficient detail to survive special demurrer. Forgery statute provides at least 5 ways of committing forgery, and impersonating another person is not required. That was the element in the briefs. Seems as though that's kind of been moved away from an argument today. Intent to defraud a specific person is not an element of the offense. And that motion should be denied, Judge.
Very briefly, Judge. As I've stated before, the statute says falsely makes or alters a writing by authority of one who did not commit such. The indictment does not say who failed to give us the authority to sign that document as the Republican. We were the Republican.
I know. All right, Mr. Rice, I think if you got something additional to add on, but I take your argument. All right. Filing false documents. We drawing straws?
We're going to stand on our brief, I guess. 2 seconds.
Sure.
Can we go out of order?
Yeah.
Would that be okay? Can we skip to 8 while they're figuring out?
I think Rico might be a meatier one. I want to make sure that we address the discovery issues if we have to break early. So let's skip to 10. This was Mr. Sadow's motion to
Thank you.
obtain the DC material.
No, he's gonna go.
Yeah.
Moving on.
We'll discovery. All right. So, Mr. Sadow reviewed the motion. I guess my first question for you would be a couple, actually. I think the first thing you ask is, can I ask the DC district judge for permission? And let's say that she says no, and then you say we should issue a subpoena. I'm wondering if the state even would have the ability or authority to do that over federal materials. So essentially, I guess what I'm getting at is there actually a legal remedy to have any of these documents? And if not, what then?
Well, the answer to that is yes, there is in fact a legal remedy, and I had thought you might bring that up, so if I may, I left copies sitting over there for everybody.
Yeah.
Well, this is an old case in the sense of being back in 1981. It's from the Georgia Court of Appeals. It has not been overruled. It has not been restricted in any fashion. The Supreme Court has cited it. The Supreme Court of Georgia has cited it as authority, and it makes it clear that a litigant in the position of President Trump has the ability under the compulsory process clause of the Sixth Amendment and equal provision of the Georgia Constitution to seek federal documents through a subpoena ducis tecum. That's precisely what happened in Beaufort. The state moved to quash the subpoena in Beaufort, went up to the Court of Appeals, and the Court of Appeals upheld the right of the defendant in that case to issue the subpoena to obtain the documents. Actually said that the TUI doctrine, as Your Honor would well know, doesn't apply in the state of Georgia. We don't even have to comply with TUI. All we have to do is show under Nixon that it's relevant and material to the case in the presentation of the defense or in the presentation of witnesses. and we are entitled to it. This is why I have brought it up the way I have. So, under the circumstances, and by all means, the state can take a look at it, write whatever brief it chooses to write. It won't find anything that in any way restricts this. I would issue a subpoena to both counsel for President Trump in D.C. as well as the special counsel's office for disclosure of what I want. So I've been very limited on this. All I'm asking for is a list of the discovery so that we were able to determine what they have. And if they were to like that, which of course the Justice Department might choose to do, it would come either before Your Honor for determination, or it would come, if they wanted to remove it, strangely enough, they could remove it to federal court. Strange thing on this, and the reason why this is so important is, if I can't get the material and you deem it relevant and material, the remedy is dismissal of the case. And therefore, I'm trying to figure out a way to obtain the material that doesn't present that situation to the court, which is why I suggested that maybe the court could contact the judge in D.C., or the prosecution here could contact the special counsel's office in D.C., or I can issue the subpoena duce tecum. And now what I can suggest to the court is why it would be necessary to do so, and I have a perfect example based on what just came out about Vice President Pence. And again, I am not suggesting that the state has a legal responsibility to obtain the documents that I'm looking for. It's not an arm of the prosecution, and I don't have evidence. I want to say I do, but I don't have evidence to show that there has been an exchange of information with the special counsel's office in D.C.
Would an exchange even be enough to draw it under? Okay.
Which is why I think the court knows me well enough from our prior dealings. I'm not going to bring something to the court's attention which doesn't have a reasonable legal basis. This would simply be the state understanding the potential repercussions of not producing the documents, seeking a way to do it with a practical means. But
And you say it's Buford as the authority that says that dismissal is the ultimate outcome? Or is it within Buford?
It is. I'm on page, I think it's page, let's see, 768, which would be the third page of the case handout, at the very bottom, where it talks about what the Attorney General could do if they don't like the subpoena or don't wish to comply. It says the Attorney General might appeal any adverse judicial order to the proper form, but without a trial court demand for the evidence, we are back where we began, and without the evidence, if it is material, the defendant ought not to be tried. And that's precisely what I'm saying here. There's no doubt that the special counsel's office in the D.C. prosecution has relevant and material information that deals with the allegations in this case. I sent along, as the court well knows, I sent along a highlighted copy of the D.C. indictment. Assume that the court's had a chance to look at that. And the D.C. indictment in count 1, which alleges a conspiracy to defraud the United States under 18 U.S.C. 371, in paragraph 8, I'm on page 3 of the indictment, co-conspirator 1, and I believe this is accurate, although there's not been a publication other than through the media in my own investigation, but I believe when you look at the indictment, there's very little doubt that who this would be. That co-conspirator number 1 is Mr. Giuliani, co-conspirator number 2 is Mr. Eastman, co-conspirator number 3 is Powell, co-conspirator number 4 is Jeffrey Clark, co-conspirator number 5 is Mr. Chesbrough, obviously all of which were indicted defendants in our case.
So the ultimate point is it seems very clear from the D.C. indictment that there's a good deal of overlap. Is that fair enough?
Remarkable.
All right, just at a minimum. Okay, so
I know from what's just been reported, another leak that came out of D.C., that, for example, with Vice President Pence, that he provided notes to DC, that is to the special counsel's office, that he's made statements to the special counsel's office, all of which he's on the proposed witness list in the previous case, number 135, which would be certainly discoverable under procedures in the state, as well as would be obtainable under the subpoena. And I'm just trying to figure out a solution to do this. This is going to take some time. My guess is the Justice Department, Special Counsel's Office, is going to fight this all the way through. And as I said, Buford might suggest the case ought not to be tried. That's one way to do it. I suggest there's other alternatives. If I can't get the information and it's about a witness, as in both cases, they can't call the witness. The third way is to wait until the DC case is completely over and then seek it in a different fashion. But this is a problem, and it's clearly information that, as you said, if you look at the two indictments, and I was going to just mention your comparison if you want me to do it. If not,
I think it speaks for itself, and you've highlighted the portions, and I've seen those. And if you need to enter that as an exhibit, we can.
I'll leave open the possibility of making an exhibit. But the only thing that's not essentially in the DC indictment is Coffee County. Everything else is basically a mirror image. It includes everything about Georgia.
Okay. No,
I'll tell you the other part of this is, that you had asked me previously about, there may be a double jeopardy motion that would fall from trial in DC before here because of the nature of the allegations. Now, I'm not saying that would work. I'm just saying that there may be something in the state double jeopardy statute, but that's not part of this. What I'm interested in now is how do I get my hands on what's clearly relevant material information, and I'm basing it on Nixon and Buford in this case. You'll see it when you shepherdize this. It's called Dean versus the state, and Dean is at 267, 306, 1996 decision by the Georgia Supreme Court, and it basically says Dean is being denied access to records for use in a criminal trial. However, in the allowance of the privilege to withhold evidence that is demonstrably relevant in a criminal trial would cut deeply into the guarantees of due process of law and gravely impair the basic function of the courts, citing U.S. versus Nixon and Buford versus the state, in which Buford says, holding that a federal regulation forbidding disclosure of departmental information must yield to a defendant's constitutional right to compulsory process. That's precisely what I'm asking.
all right. I think I understand your argument, Mr. Sadow. So I know the Buford case wasn't cited in the motion. Does the state feel prepared to respond to this today?
As we can respond briefly.
Good afternoon, Your Honor.
Let's have you name for the record.
Yes, sir. Donald Wakeford for the state. Just real quickly, Your Honor, no, we're not going to provide some kind of response to a case that we just got, not suggesting it was
Sure.
any kind of...
Obviously, this is a preliminary, just kind of exploration of where we think this might lead.
So, especially because there are a lot of very grave consequences, which Mr. Sadow is mentioning, and so certainly we're not going to go articulate any kind of response to anything at this stage. But obviously, what this requires is some closer consideration. While obviously Mr. Wade is the one who speaks for the team in most regards, I will say that this investigation, as the district attorney has made clear, is independent from the investigation or any kind of case that is anywhere else regarding defendant Trump and the other defendants at the table. So it's sort of, to the extent that it is being made our business, we intend to cooperate. But our position is quite simply that we don't have authority over the Department of Justice, and certainly not a federal judge, and that at this stage there is no role for us to play, absent an order from this court directing how we should move forward, because we don't have anything to draw upon for the service of Mr. Sadow.
I don't know if that's exactly what Mr. Sadow would be asking for, and I don't think that's something I would ever tell you to do. I think it's really just ball might be in your court as to item number one. You say, it seems to me like you're making it very clear there's been obviously no coordination, but not even any kind of line of communication or sharing of any kind between the Fulton County and the special counsel, but perhaps Mr. Sadow suggesting that it might be worth a phone call. That's not something that I would ever order, but might be worth it. So I guess we're just flagging that, and probably the sooner we're able to find a road forward, the sooner we can get the discovery issues taken care of. I don't think there's anything really else for us to determine or decide today, but unless there's something else you wanted to add.
Well, just this notion that if they somehow do not cooperate and comply, then our case should be dismissed based upon.
I think we'd be a long way from that. I think even Mr. Sadow concedes that. I think yeah, but it's obviously something that we need to be mindful of here as we make our way through discovery and turning it over. And maybe we'll have more enlightenment if we know what the special counsel's position is on it. I don't know who would they'd be more open to taking a phone call from. I don't know. But I'll wait for direction from the parties on that, because right now the motion was to obtain access. I guess we've had a hearing as requested by the motion, and we can reconvene at another date to have an update and see where we are. And if the state wants to avail itself of position one and bring us back some more information, I guess that's their prerogative, but they don't have to.
But just for clarity's sake, the state does not plan to take any action on this unless the court is ordering us to do something. We're not on our volition taking any action.
Okay. And in that case, would the state have a position of whether the court, as requested in item 2, should be reaching out to the district court in D.C.? Or is this something we need to digest?
I think we have to stand mute on that because that's not our business. I think that counsel should probably start with issuing his subpoena and see how far he gets with it.
Okay. Would I think in the Buford case I'm reading here that it was the state that intervened to quash. I guess that would be something worth flagging. Again, maybe something that the state needs more time to think about. Would the state be intending to intervene and move to quash, or would be waiting to see what the Department of Justice says?
To the extent, Your Honor, that you're looking for guidance as predicated by the case that we were just handed and that was not in the motion, I just think
I'm really just kind of more flagging issues to think through.
Okay.
For the next time we convene.
Understood.
All right.
If
Yes,
I
sir.
might, Your Honor, what I'd like to do in the interim, and we can obviously get back together and discuss this, but I will go ahead and prepare subpoenas, and maybe the next time we're here, depending on where we are, I would seek the court's permission to issue such subpoenas under appropriate order. I know normally we just issue subpoenas, but I don't want Department of Justice, the special counsel's office coming in and saying, but you don't have any order that says you're allowed to issue the subpoena. So I'll prepare them and then we'll go from there.
All right. And let me just flag this as well, since is there an issue here where this is an extraterritorial out-of-state subpoena where you have to go through some other process?
I do not think so. I do not believe so. If the way Buford is set up, they've kind of said in that case, you may have subpoenaed the wrong person. Maybe it would have been better if you did it to the Attorney General, but you're a right to compulsory process. Now, I think what you're asking me is, do we have to do like an out-of-state witness?
Yes, that's exactly
It's
right.
not a state entity, though. There's no provision. And
Special
I
counsel's
could-
not in Georgia.
Theoretically, I could serve the U.S. Attorney's Office in the Northern District of Georgia if it went to DOJ, but then special counsel becomes a special issue because they're different in part than DOJ, although they're under federal regulations. Or I can serve my counsel up in D.C., and they can take service and say, I'm sorry, I can't turn it over. And then you could bring them in and potentially order them to disclose it because they have it. And then D.C. will, then the special counsel's office will come in and say, no, you can't disclose it. So
Okay.
I'll just get it prepared so that you at least can see it.
All
Not
right.
going to be any more detail, though, than what I said. I'm not looking for the evidence. I'm just looking for a list so that we can begin the process.
Well, to that end, though, why wouldn't you be just asking for all the evidence as well, if that's the end
Then
goal?
I can't show relevance or materiality to what the specific items that I would want to have. I want to make sure that when I'm presenting it, if it doesn't have something to do with our case or witnesses in our case, I don't want it, and I don't believe I'd be entitled to it. If it has to do with witnesses like in our case, like Department of Justice officials, Vice President Pence, there was actually another thing recently, Scott Perry, Representative Perry, some of his material was unleashed or unsealed yesterday and then sealed back up again. He's a witness, 133 in our case. So I would want to make it as specific as possible so that Your Honor would be in a position to be able to say, why would you want this if it has nothing to do with our case?
All right. Okay. Any last thoughts from the state or anything to add?
Nothing, Your Honor. No, I just wanted to, nothing further, Your Honor.
Okay. We'll put a pin in it for next time. All right. So my thought here to best utilize the time we have remaining is that, with apologies to Ms. Palmer and Mr. Floyd, I think we have to come back on RICO. There's just always a lot to that. I think that would be, again, as much as there was with the ECA, not something we just want to jam through. So I'm thinking we could continue with item 7, the filing false documents, the perjury count, and then the catch-all, whatever's left, and call it a day and come back on RICO.
Judge, the filing false documents brings up the most exciting portion of today, statutory construction. And recognizing how long we've been here already, I will make this as concise as possible. Section 1610-20.1 is filing a false document, and this turns on what the definition of a document is. 2014, amended the section of the statute and inserted a more expansive definition of document. There's basically a two-part definition of the word document. First one is inscribed on a tangible medium, stored in electronic or other medium, retrievable and receivable. The indictment satisfies, or the elector certificate satisfies that first part. The second part is the one that matters. The definition goes on to say, shall include but not be limited to liens, encumbrances, documents of title, instruments relating to security interest in or title to real or personal property, or other record statements and representations of fact, law. Now, it's beyond dispute that the first part of that definition, the first part of the second prong, liens, encumbrances, documents, title, instruments, that does all relate to security instruments. So the issue then is, does the trailing word, other records, expand the scope of this statute beyond what was previously listed? And the answer to that, Your Honor, is no. If you follow the case, the Georgia Supreme Court case of Kinslow, or the U.S. Supreme Court case of Gates versus the United States, as a matter of statutory construction.
So I'm remembering this one obviously from the order. Why does the shall include but shall not be limited to language not override? And that is a very easy way to distinguish Yates.
Because, Judge, when it says shall include but not be limited to, it is then listing everything starting with the liens and encumbrances. It is not, if it said it applies to liens, encumbrances, etc., but also additional elements, then yes, that would be fine. But the shall include but not be limited to begins the illustrative list of potential types of documents. And when you're looking at those lists, the trailing word, the final little segment of other record statements and representations, that cannot be interpreted under Yates or Kinslow to expand it beyond what the preceding. Because when the court is construing the statute, they must give effect and meaning to all the words in the statute. And if we interpreted that other records part of the definition in the manner that the state suggests, and frankly in the manner that you ruled on the speedy trial defendants, then it swallows, subsumes everything that preceded. And we cannot interpret it, but the Georgia Supreme Court and the U.S. Supreme Court has made it clear that we cannot interpret a statute in a manner that does that. We cannot take that trailing word that basically makes everything prior to it in that illustrative list surplusage or redundant. And with the construction that you gave it in your order, speedy trial defense, that's effectively what you've done. Liens, encumbrances, etc., has no meaning. All they needed to say was other records. But when they said other records, they are essentially trying to catch in any permutations of those preceding terms. And frankly, when you look at the amendment, the House Bill 985, it specifically says, change provisions relating to filing false liens or encumbrances against public employees, provide for a definition to expand the protection against filing of false liens or documents to all citizens, provide for exceptions, It did not explode or expand the definition document in a way that created much broader application than what that section had been targeted to prior to 214 and targeted to after 214. And indeed, the bill itself was also titled Liens and Encumbrances. And it is a matter of constitutional law in the state of Georgia that you cannot pass a bill with provisions that aren't indicated in the title of the act. As the Georgia Supreme Court said in Mead Court, the purpose of the constitutional provision requiring that the act's title must alert the reader to the matters contained in its body is to protect against surprise legislation. And if this court were to interpret that other records part of the definition in the way that it did with the speedy trial defendants, then that's what we have. We have a surprise law. We have surprise legislation. We have surprise criminalization.
Is the case you cited on an act's title, is that a situation where because of a defective bill title that, tell me more about that case. What actual effect did that have if a bill's title was insufficient?
What it said was, similar to this, what we're trying to do in this case, the bill's title constrains, the application and effect of the statute. You cannot title something indicating one thing and then interpret the language of the statute above and beyond and great expanse of what's indicated in the title. So it's essentially words of limitation.
All right, so while you're up, why don't we do perjury as well?
Judge, that is very brief. And
you just say that the state hasn't outlined why it's material.
Yeah, their allegation in the count is that effectively it comes down to the statements are material to the statements. And while an indictment to survive the special demurrer doesn't need to contain a full, detailed argument and exposition of what the materiality is, it does have to include some indication of materiality. It can't just say it's material because the statements are material to themselves. And that's really what that count boils down to. That's what the state has tried to do, and that's what the argument has suggested.
So just how would you suggest, like a hypothetical indictment would show that materiality? I mean, doesn't something speak for itself when they're saying that someone's testimony could have influenced the grand jury and that's always going to be material if the grand jury decided to believe that person's testimony?
Every false statement under oath does not constitute perjury. And under that kind of general scenario that you just painted, every false statement would constitute perjury, because you can say, well, they testified before the special grand jury,
right.
They said something false.
So it's an issue of circumstances and fact.
Yes. And again, it doesn't have to be incredibly detailed, but there has to be something more than what we have in this indictment, which is the statements are material to themselves, the content of the statements. requires more.
All right, Judge, hopefully I'll take us home with this. So the final false documents counts, quickly through this. Again, each of them allege all the essential elements. They allege enough to survive a special murder. Documents and issues are documents. The document defines documents as, among other things, information that is inscribed on a tangible medium. As the court pointed out, the shall include but not be limited to language. They do acknowledge it in their argument. They do acknowledge this provision in the argument. It's kind of avoided in the briefing. But again, information means words, inscribed on means written on, tangible medium is paper. These are documents. Going to the 2014 change, the General Assembly, again, specifically expanded the applicability of 161020.1 in 2014. But prior to 2014, the statute only criminalized filing false liens and encumbrances against public employees that largely tracked 18 U.S.C. 1521. House Bill 985, as the defense pointed out, signed into law, made it a crime to file any false document in any public record or court of Georgia or the United States. And the 2014 amendment did add a broad definition for the word document. It means information inscribed on a tangible medium. All these other things shall not be limited to, shall include but not be limited to the liens and encumbrances. That doesn't exclude, or that doesn't limit the types of documents to just that list or things like it. It just gives examples. I can't get into the mind of the legislature, but I would imagine this is just so that kind of the original iteration of the statute kind of carried through. I don't know why they left that there, but it doesn't change the fact that any information inscribed on a tangible medium is a document. The argument about the title not matching the contents, that's with regard to the title of the bill, not the title of the statute once it's been enacted. So House Bill 985's title was, I won't read the whole thing, but a bill to be enacted, or a bill to be entitled an act to amend this section of the code to do X, Y, Z. And the bill did amend that section of the code to do X, Y, Z. So there's not an unconstitutional variance in the name of the bill and what the bill did. I think the defense is confusing the name of a bill with the name of a statute. And we know from case law that the heading, title or heading of the statute really doesn't mean anything. That comes from Marta versus McCain, 135 Georgia at 460, 1975 case. I don't even think that the titles of the statutes are created by the legislature. I think that's created by the people who put the laws into the books and then distribute them out to lawyers like us. Again, just hitting some of the other arguments, they say that there's no allegation of what was filed by whom or whether it was in a pleading or attached as an exhibit. Those are not elements of the offenses in general. And again, taking a step further, these are attempt and conspiracy to commit filing false documents, so even more so not elements of the offense, of those offenses. In any case, the indictment does specify what the document was. It was a document titled Certificate of the Votes of the 2020 electors from Georgia. It specified who did something with it. It said that Schaefer, Still, and Latham placed that document into the United States mail, sent it off to the Chief Judge of the Northern District of Georgia. The defendants again attempt to add additional elements to the offense. Not an element of the offense that the false document is material to anything. It's not an element of the offense that the false document is placed in the record in any particular way. Those simply aren't pleading requirements in this case. Motion as to those counts should be denied. Essential elements are pled. There's enough to survive special demur. The documents are documents. The remaining arguments seek to add elements to the offense that are just not part of the statute. Finally, the perjury argument, I'm a little bit confused by it, but again, it alleges enough to, it alleges the essential elements, it alleges enough to survive special demur. The defense says that it fails to allege materiality. The indictment specifically alleges that the false statements were material to the accused's own involvement in the December 14th, 2020 meeting of Trump presidential elected nominees in Fulton County, Georgia, and to the accused's communications with others involved in said meeting the issues in question. So it identifies exactly why they're material. He didn't lie about what color shirt he was wearing. He lied about something that was an issue in question before the special purpose grand jury. That is sufficient to withstand demurrer. And also, they cited some cases concerning sufficiency of the evidence at trial. Again, as we've discussed, that's entirely different than a pleading requirement. For those reasons, Judge, you should deny these motions. I think that takes us to the end.
Maybe.
Maybe.
I think we still had there'd been a request to also address other discovery or motions issues and just other general housekeeping. So open it up to the floor on that. If anyone wants to jump up first.
Your Honor, do you want me to go to the podium or is this so? Can you hear me?
I can hear you just fine. Thank you, Mr. Sadow.
I understand that Madam Court Reporter is working as hard as she possibly can while everything's going on here. But I'd like to see if we can figure out a way that we can assist her in potentially getting transcripts done. She's got a load that she carries is worse than anybody. And we're trying to work with her, and she's been very kind in saying to us that she's getting around to getting them done. I'm hoping maybe we can figure out a solution and can get them done a little faster.
Well, on that point, Mr. Sadow, we've been looking into this as well. On the front end, I'll say one of the reasons that we record every word is I'm going to be rewatching this, and I would think that you could also rewatch it and hear what you need to. And if it's not an evidentiary hearing, I don't know if a transcript would be as necessary. It's just argument here. Logistically, though, we'd explored whether if there's a way to expedite transcripts. The issue was we can't outsource that. No matter how much money you offer, we can't outsource it. Ms. Smith has to do that, and in the meantime, we also have trials. We're starting one on Monday.
I understand all of that. That's why I'm most concerned. For example, obviously, you're correct about everything that watching the videos and the YouTube taping. I'm most concerned about the pleas of co-defendants, because if I understand correctly, we can't get the exhibits until those exhibits are made part of the transcript, and that kind of a
Sure.
chicken and an egg thing.
And those aren't long proceedings, and so those we'll see what we can do to place those at the top of the priority list. But these longer argument hearings, I wouldn't expect to see transcripts on those expedited. If there's an interlocutory that we have to start talking about, then obviously that would, I would imagine, be part of the record. We'll just have to go through that case by case. But if there's a specific aspect you're saying you absolutely need, we'll keep seeing what we can do. But I just don't think logistically it's even.
Let's stay on as far as being able to get transcripts of the co-defendants and the exhibits to go with.
All right. Anyone else on that issue? Okay. All right. Opening the floor again to just anything else in general.
Judge, just one clarification on the supplemental briefs. Given that we've covered a lot of ground today, is the court willing to allow us to take up any of the matters? I mean, obviously not to be repeating things that we've already argued, but just to supplement any of the arguments on any of those issues. We'd request that we be allowed to do that in our supplemental briefs.
So, I think the most effective way in a supplemental brief is to say something new. But if there's a point you think there's a new way to say it, have at it.
Okay, thank you,
That's
Judge.
fine.
Your Honor, hearing that to Mr. Clark, since you've opened the floor, I will take the opportunity to say that we will be following in Mr. Sadow's footsteps with respect to discovery of information in the hands of the federal government that we think is relevant to our defense. And we will be preparing something to reflect that shortly.
All right, so noted.
Is there any indication when the court is planning to have the RICO arguments?
Well, I was going to probably follow that up when we see everyone's schedules, which I don't think we want to pull out our calendars here. I think that's something we can take up through email. And if we can get them this month, I know the week of the 18th, it's kind of just been a catch-all hearings. I've got trial weeks next week and the week following, and then the week of the 18th is a lot of hearings, so that'd probably be where I'd start asking everyone if we can get the RICO arguments in.
What's the starting point?
The week of the 18th. And we can take it up from there on availability. Anything else? All right. Not seeing anything. Have a great weekend, everyone. Thank you.
Well, I'll fix that. Try to figure that. Is it needed for a reason? John, nice to see you. Good to see you, Bruce. Well, you too.
What is it?
Oh, I don't know what that is. I know that's right there. I guess
Is this 7? Yeah. That's 7? You gave me one earlier that I signed. This is round 2 through 4 of discovering a This is just everything you've already turned over already. You're turning it over again in a different format. Is that it?
That was so big deal.
Grant, is he?
I got one for you.
This is an good work. Yeah, you know.
You did the best you could. That's all you can ask. You did the best.
No, I have all that.
Yeah, have fun at the football game.
I'm not going to.
Oh, good job. Take care. Good job today. Thanks.
Yeah, no, I was the best today.
Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.